Hello, and welcome to the ACOEM Ready, Set, Comply Genetic Information Non-Discrimination Act of 2008, the GINA webinar. Today's program will provide an overview of GINA's requirements and what you need to consider to comply, as well as an understanding of the new notification of breach requirement under HIPAA. This program is being recorded. Today's program qualifies for 1.5 hours of CME and MOC credit. You received a verification form with today's instructions, or you can follow the link that was in the instructions. No certificates will be sent to you, but your transcript of this and other ACOEM educational programs can be viewed and printed from the ACOEM website. Members and non-members can both view their transcript directly from the website. Today's program will consist of approximately 70 minutes of lecture with questions at the end. We will address questions as time permits and suggest that you submit your questions early for consideration. We are only accepting questions electronically. On the screen, you can see how to open the question box in order to submit your questions. This was also in the PDF file of your handouts you received with the instructions. We are very fortunate today to have Tiffany Santos as our presenter and Dr. Pamela Hamel as our moderator. On behalf of the presenters and planning members, we would like to announce there are no disclosures to be made. So it is my pleasure to turn the program over to Dr. Pamela Hamel. Dr. Hamel, you may begin.
Thank you, and welcome everyone. Thanks for joining us today for a talk on really updates around the Genetic Information Non-Discrimination Act and the HITECH Act, because these are two specific areas that we feel will begin to impact the practice of occupational medicine and the practice of medicine in general for our members. So today I am really pleased to have Tiffany Santos, who is the director with the law firm of Trucker Huss in San Francisco, with us. She primarily focuses on qualified retirement plans and health and welfare plans. She assists her clients on a number of administrative issues, on summary plan descriptions and amendments, IRS and DOL investigations, and reviews of service provider agreements. And she frequently makes presentations on employee benefits matters. She's a member of the American Bar Association and the State Bar of California, in addition to a number of other bar associations. And she received her BA degree in integrative biology from the University of California at Berkeley and her JD degree from the University of San Francisco Law School. I've been privileged to work with Tiffany for a number of years as a consultant to Cisco on our health and welfare plans, and she is the go-to person when we have questions about these kind of legal issues. So she's prepared a very comprehensive presentation today. We will take about an hour or so to go through all of the content and then open it up for questions for the last about 15 minutes or so of the presentation today. So as Sandy mentioned, please type in your questions and then we will be reading them off at the end of the presentation. So with that, welcome Tiffany, and I'll turn this session over to you.
Thank you, Pam. As Pam mentioned, unless you've been living under a rock or on a different planet, health plan legislation, any kind of legislation that affects health plans and the practice of medicine, the delivery of health care have been hot button topics, both at the state level and at the federal level. And that has resulted in the enactment of various pieces of legislation that have an impact on how the practice of medicine is conducted and how employers provide health plan benefits to their employees. Most of the legislation going out right now, most of the talk is about healthcare reform, but there are some issues, health-related issues that are already effective now and that impact your work and employers and how they provide health plan benefits right now. As Pam said, we're going to be going over the Genetic Information Non-Discrimination Act of 2008 that has impacts on both employers and the health plans and health insurance issuers, and the HITECH Act of 2009. That act made significant changes to HIPAA, the HIPAA privacy rule and the security rule. So let's get started. GINA, the Genetic Information Non-Discrimination Act, was actually enacted last year under the Bush administration, and it consists of two titles. Title I is impacts health plans and health insurance issuers and HMOs, and that essentially prohibits discrimination in health coverage based on genetic information and sets limits on the extent to which genetic information can be collected. Title II of GINA prohibits discrimination in employment based on genetic information and limits the extent to which employers can acquire and disclose such information. Right now, there is no final guidance on, let me back up and say, Title I is actually enforced by the Department of Labor, the Internal Revenue Service, or IRS, and the Department of Health and Human Services. Title II, which is geared towards employers, is enforced by the EEOC. So because they're different agencies, they have different timelines for issuing regulations and different standards for issuing regulations. We have final regulations for implementing Title I, which we'll be going over now today, but there aren't final regulations yet or final guidance yet to implement Title II, where EEOC is still in the process of evaluating the comments they received in connection with the initial preliminary guidance that they issued and the statutory limitations of GINA. So that should be forthcoming. But what we do know about GINA is that it will limit the extent to which employers can collect genetic information when they make disability-related inquiries post-employment, so to current employees. So we're not yet sure what that means, but we do know that it won't generally limit or expand what's the obligations that are currently in place to comply with workers' compensation laws. It will not, it will still, GINA will permit, will not place any limits really on the collection of genetic information if it's necessary for purposes of administering an FMLA leave, like if that information is necessary for the physician certification. GINA won't place any limits on that. It also won't impact the collection of genetic information if it's necessary to support a request for a reasonable accommodation under the applicable federal or state laws. So it shouldn't impact employers' obligations under other laws. So it's still, we're still waiting on to see what impact it really will have on employers. That's forthcoming. In any event, we know what we know what GINA limits with respect to Title I. Essentially, what it does is, as of October 1, 2009, these final regulations were issued. And what they do is, if you have a plan that has a plan year that is a calendar year, meaning it starts as of January 1, 2010, each year, January 1, then you have to comply with the new GINA regulations as of the first of next year, January 1, 2010. And what does GINA cover? It's important to understand what GINA means with respect to genetic information, because it's a pretty broad definition. Genetic information includes what you would think genetic information is. It's information about a person's genetic test. So a genetic test would be any analysis of human DNA, RNA, chromosomes, proteins, or metabolites if the test detects genotypes, mutations, or chromosomal changes. So if a person undergoes a test to determine whether they have the gene that predisposes them to breast cancer, then that would qualify as a genetic test. But other types of tests, like an HIV test, complete blood count test, cholesterol test, a liver function test, a drug test, those aren't considered genetic tests for purposes of GINA. So that wouldn't fall under the definition of genetic information and wouldn't be subject to the restrictions of GINA. GINA also, this is the expansive part of GINA's definition, because genetic information now includes, also includes genetic tests of not just the individual, but the individual's family members as well. So that could mean an employee's dependents and any other dependent who's of the first, second, third, or fourth degree relative. So that could be an employee's mother, patient's mother, grandmother, great-grandmother, and great-great-grandmother. And it also doesn't matter whether someone is related to that individual by blood or marriage, or if that person is not a full-blooded relative. So it's a pretty expansive definition. So it would cover relatives by marriage and half-siblings and such. One of the biggest expansions of the definition is perhaps the fact that genetic information also includes family medical history. So if someone has a family medical history of cancer, but that person actually doesn't have cancer themselves, that is considered genetic information. So genetic information also includes genetic services, whether someone has received any kind of genetic testing, genetic counseling, or genetic education. The definition of genetic information also extends to any fetuses that are carried by a pregnant individual, and also any embryos. Let's say you have an individual who is participating in assisted reproductive technology, and there's an embryo out there that was produced in connection with that. The genetic information of that embryo is protected by GINA. So what do we know that GINA does? It prohibits a health plan, it prohibits health insurance issuers as well from increasing any group premiums or any contribution amounts on the basis of genetic information. It also prohibits those entities from requesting or requiring that an individual undergo genetic testing. There are 3 exceptions to that we'll go over. And it prohibits plans from requesting, requiring, or purchasing genetic information if it's prior to or in connection with an individual's enrollment in a plan, or if it's for any type of underwriting purposes. We're going to be going over what underwriting purposes means, because GINA will have a significant impact. Because of the definition of underwriting, it will have a significant impact on how wellness programs and health risk assessments are conducted by employers. Under GINA, as I said, health plans and health insurance issuers can't increase contributions or premiums based on genetic information. So even if you have a health plan or health insurance issuer has genetic information now, you can't increase premiums or contributions on the basis of that genetic information that you collected prior to the effective date of GINA if the increase in premium occurs after the effective date of GINA. So that is something that can't be done. Also, GINA only protects genetic information. So if you know that your population of employees, there's a high incidence of cancer or whatever disease, the employees actually have the disease, you can actually increase the premiums and contributions on the basis of that actual experience and claims information, because that information is not genetic information, because the people already have the disease. Let me back up and say that if you have an employee who has polycystic kidney disease, and that's a genetic or hereditary disorder, you can't, and you know that employee has 2 minor children dependents who are covered by the plan. You cannot increase a premium based because those children might develop polycystic kidney disease, but you can increase premiums because that person actually has polycystic disease, as well as some other employees in the population. Generally speaking, GINA prohibits health plans and health insurers from requesting or requiring that an individual or an individual's family member undergo genetic testing. However, there are some carve-outs to this. Obviously, the federal government does not want to interfere with the practice of medicine and the provision of care to individuals. So GINA has places no restriction on a healthcare provider's ability to request that an individual undergo genetic testing if they're actually providing care to that individual. So there's no limitation on that. Health plans can request that someone undergo genetic testing, but only if they meet the following requirements. The request is in writing, the compliance with the test with the request is voluntary, there's no impact on their enrollment in the plan or whatever amount they pay for coverage under the plan, and the plan tells the Secretary of Health and Human Services that it's conducting the research. Also, there's no impact on using the results of any genetic test if that information is necessary to make a determination as to whether a claim is payable by a plan. So if an employee were to undergo genetic testing in connection with treatment that they receive and were to submit a claim for benefits for the entire treatment, the plan can actually look at that information and determine whether the genetic test was medically necessary and to evaluate that, and that's completely permissible under GINA. And as you know, since we've been living under the umbrella of HIPAA for the last, almost 7 years, when an employer or health plan makes these determinations, they can only use the minimum amount of PHI or information necessary to make that determination. So you can't necessarily look at a person's entire claims history if that information is not needed to determine whether this test is payable or not. As I referenced earlier, GINA prohibits plans and health insurance issuers from collecting genetic information if it's prior to or in connection with enrollment. So that means you cannot request genetic information if it's prior to the individual's effective date of coverage under the plan. And it also prohibits health plans from collecting genetic information for underwriting purposes. Now, underwriting is not just limited to rating and getting a determination from the insurance company as to what the renewal rate is. It's broader than that. Underwriting includes rules for determining eligibility for benefits. So whether someone is entitled to participate in disease management, that's considered underwriting. Whether someone is entitled to a different deductible or other cost-sharing arrangement. Let's say you have an employee. Let's say you have you work with an employer that provides for a lower deductible to those employees who participate in a wellness program or who complete a health risk assessment or HRA, that's considered underwriting. If you condition any discount, rebate, or other premium differential for in exchange for, if someone were to complete an HRA or if they participate in a wellness program, if that HRA includes or health risk assessment includes questions about family medical history, then you may run into problems under GINA. You also can apply a pre-existing condition exclusion against someone on the basis of their genetic information. So you can't say that someone won't get coverage under the plan for a set period of time because they have a predisposition towards some disease. Because of the broad definition of underwriting and because you cannot collect genetic information prior to or in connection with enrollment, GINA will have a significant impact on how health risk assessments are designed and administered and how wellness programs are designed and administered. So let's go over how they can be impacted. For example, if you provide a reward for completing a health risk assessment, there's a problem under GINA if that health risk assessment includes questions about family medical history or whether someone has received genetic services or asked for results of genetic tests, because that's considered underwriting. And the reward could be a discount on premiums, a cash bonus payment, anything. If that HRA has those questions in it, you run the risk of violating GINA. It doesn't matter what their reward is. It could be $10 or $10,000. There's a problem under GINA. If an employer requests that someone complete an HRA prior to enrollment and that HRA includes questions about family medical history, that's also a problem under GINA, even if there is no reward. The problem is you're getting it prior to that person's enrollment in the plan. The problem is that the government does not want employers, plans, HMOs from conditioning any kind of coverage, health plan coverage, if it looks like they're not going to extend coverage to someone because they have genetic information that's probably not helpful in terms of underwriting in the future for the employer. Essentially, you don't want to the government doesn't want to place any barriers on an individual's ability to gain entry into an employee benefit plan or other insurance arrangements. Under GINA, an HRA, if the HRA includes questions about family medical history and the results or the responses provided on that to those questions results in that person being eligible for a disease management program, that is a violation of GINA. Because you cannot condition eligibility for benefits on genetic information, on the collection of an HRA that collects genetic information. An HRA will also violate GINA if it includes broadly worded questions like, is there anything else relevant to your health that you would like us to know or discuss with you? If someone were to provide genetic information in response to that question, like, by the way, I have a family history of polycystic kidney disease, or, I just got a genetic test a couple weeks ago. That is a violation of GINA. Even though the HRA didn't specifically ask for genetic information, the fact that that broadly worded question resulted in the collection of that genetic information, that's a violation of GINA. To combat this problem, combat this issue, an HRA can be designed to say, in answering this question, you should not include any genetic information. And so you can also clarify that and say, do not include any family medical history, any information related to genetic testing, genetic services, genetic counseling, and such. So how can HRA still be used and not violate GINA? Well, you can remove the genetic information, remove any questions that request genetic information from the HRA. If particularly you want to do this, if the health plan offers rewards or other incentives in exchange for completing the HRA. You can also just not provide any rewards for completing the HRA. That's fine, but only if you require or request employees to complete the HRA after their enrollment in the plan. If you do it in connection with their enrollment, prior to enrollment, that's a no-no, even if there is no reward. Or you can have a two-part HRA. One part, the HRA provides for a reward for completing it, and the second part is HRA number 2, and it actually has genetic information questions on it, like it asks questions about family medical history. That's fine as long as HRA number 2 says that completing HRA number 2 will not affect the reward that you receive, that you're entitled to receive if you complete HRA number 1. That's fine. Complying with GINA also requires that a covered entity make some conforming changes to their HIPAA policies and procedures. So essentially all you have to do is say that genetic information is included within the definition of protected health information, and that the plan will not use or disclose genetic information for underwriting purposes. And obviously you can't actually do that. You actually have to say it and actually not do it. So it's important that you examine all your current documents and make sure that all of the documents are being administered in accordance with their terms. The second half of our discussion will focus on the HITECH Act of 2009. Perhaps one of the big things that came out of this HITECH Act was part of the American Recovery and Reinvestment Act, which was called ARROW. That is the act that brought forth the COBRA subsidy. So that was a thing that was causing a lot of employers to go running around going, what the heck am I doing? How do I deal with this? So this was another part of ARRA. Essentially what the HITECH Act does is it amended HIPAA, the Health Insurance Portability and Accountability Act, specifically the HIPAA Privacy Rule and the HIPAA Security Rule. And it also provided for much money in terms of the development of electronic health records and the ability to provide for the easy transmission of such information. A lot of the provisions of the HITECH Act are still being fleshed out, and within the HITECH Act you'll see that the various agencies that are charged with enforcing HIPAA are directed to issue regulations or other guidance in the next few years. So this is something that we need to keep on our radar because, as we'll talk about with regard to the changes that the HITECH Act made to HIPAA, there are staggered effective dates for a lot of these things. One of the things it did was it improved enforcement and increased the penalties that are available for violations of HIPAA. The HITECH Act now provides for the direct regulation of business associates of covered entities. It enhanced some of the individual rights that are available under HIPAA, but particularly that protected health information that's in the form of what's called electronic health records. And it provides for a new notice of breach requirement. Under HIPAA, this is actually a change under the HITECH Act. This is a change that actually became effective as of the date of the enactment of the HITECH Act, which means it's effective. It's been effective since February 17th or February 18th, 2009. So if you violate HIPAA, any privacy rule or security rule provision, different penalties can be assessed on you by the Department of Health and Human Services. The penalties are now tiered, and they're tiered on the basis of your level of culpability. So it ranges from $100 per violation to $50,000 per violation if the violation was due to willful neglect. So per violation means if you violate any specific provision of HIPAA, privacy rule, for example, if you violate with respect to more than one individual, that's a violation per individual. So you could be, if you violate any provision of HIPAA, that means you could be subject, to significant penalties because it's a per violation and the per violations per affected individual. In certain instances, the penalties can be waived by the Department of Health and Human Services if the violation would be excessive relative to the violation and the level of culpability was not willful neglect. And a new thing, starting in 2012, once regulations are issued by the Department of Health and Human Services, if a covered entity or business associate violates HIPAA and is assessed a penalty under HIPAA, then a percentage of those civil penalties can be collected by the individuals who are actually harmed by the violation. So this is something where individuals can be compensated for whatever harm they've suffered in connection with a violation. States Attorneys General now have enforcement authority with respect to HIPAA violations. So various states like California have extensive privacy laws. This particular provision allows a state to not only enforce its own state privacy laws, as they can also enforce violations of HIPAA as well. As you know, HIPAA only provides a floor of safeguards. If there is a state law that provides more stringent or stricter protections and doesn't conflict with HIPAA, then that state law will apply to that covered entity. Also, if you're a covered entity or a business associate, you can now be subject to audit by the Department of Health and Human Services. So the Department of Health and Human Services can randomly or pursuant to a complaint can send you a letter saying, show me your HIPAA policies and procedures, show me how you comply. So that's a new thing that was clarified by the HITECH Act. As I referenced earlier, the HITECH Act expanded HIPAA so that now it directly regulates business associates. It statutorily requires business associates like legal service providers, third-party administrators, billing companies to comply with the requirements of the privacy and security rules. That means business associates will be required to appoint privacy and security officers, develop HIPAA policies and procedures, and implement administrative, technical, and physical safeguards to comply with HIPAA. If a business associate does not, it will be subject to the same civil penalties and criminal penalties and enforcement action that any covered entity is now subject to. So Department of Health and Human Services can directly penalize business associates for violating HIPAA. What does this mean? The Department of Health and Human Services, I should back up and say Congress put in this requirement in a weird way. What it requires, what it does is requires covered entities like health plans and healthcare providers and healthcare clearinghouses to actually amend their business associate agreements so that it reflects these new requirements. So, the business associate agreements will have to be amended to say that business associates have to statutorily comply with these new requirements. So it's a weird way of saying that business associates are subject to the privacy rule because it requires you to amend a contract to say that you have to. But in any event, if you are a covered entity and you're required to comply with HIPAA, it gives you extra protections because now you know that the entities that you're giving you're delegating certain responsibilities to will have to comply with the Department of Health and Human Services regulations or be subject to their penalties, as well as any other penalties that you may be entitled to or remedies you may be entitled to because they breached your contract. One of the things that HIPAA does, it now enhances some of those individual rights that people have under HIPAA. Right now, under HIPAA, someone can request that a covered entity restrict how the covered entity or health plan uses or discloses protected health information, and the covered entity is actually not required to comply with that request. Under the HITECH Act, entities will be required to comply with those requests to limit the disclosure of protected health information if the person has paid in full for the service or the item. So for example, if someone were to go see their doctor and were to pay for that office visit in full, meaning there's no claim to be submitted to the health plan, then that person can make a request to that doctor and say, I don't want you to disclose any of the information relating to this visit to any party, even if it's for payment or healthcare operations activities. If that person makes such a request, the doctor has to honor that request. To the extent that you're a covered entity and you maintain electronic health records, and electronic health records are defined to be health-related information on an individual that is created, gathered, managed, and consulted by authorized healthcare clinicians and staff. If you maintain electronic health records, you'll now be required to account for all disclosures of that PHI, including if it's for treatment, payment, and healthcare operations activities. Before, under HIPAA, when it was originally enacted and issued, you weren't required to keep track of those uses and disclosures. If you're an entity that maintains electronic health records, then you'll be required to track that information. If you're an entity that has electronic health records, you'll also be required to transmit that information in that format if someone makes a request to the plan or covered entity to send it somewhere. That's a new thing. Essentially what this provision is intended to do is intended to facilitate the transmission of electronic health information. So if you have an individual who has that information in electronic form, you have to direct it to the place that that person directs you to send that to under the HITECH Act. The HITECH Act also makes changes to the minimum necessary rule. We expect some guidance on this sometime next year in August. And what it essentially does, it requires business associates and covered entities to only use limited data sets. Limited data sets is PHI, which is stripped of various individual identifiers like names, postal address information, phone numbers, and dates. If the reason you need to use or disclose PHI, if you need some of those identifiers like names, for example, to do claims payments, then you have to justify that. You have to say, I need this information, or in order to facilitate claims payment, names of the party that received the services relating to the claim have to be identified to verify eligibility. Therefore, a limited data set is not sufficient to carry out the purpose of the use or disclosure, and we're under the minimum necessary rule. Names can be transmitted. So this will probably have an impact on covered entities because it will probably require, for those types of routine uses and disclosures, it will probably require you to include or revise your policies and procedures to explicitly state that limited data sets are insufficient for the purpose of carrying out those particular uses and disclosures, for example, claims payment. The last topic that we're going to talk about is the new notice of breach requirements. The final interim rules to implement this were actually issued on August 24, 2009. Under the HITECH Act, which was enacted back in February, the new notice of breach requirement was to be effective 30 days after those regulations were issued. So technically, the new notice of breach requirement is effective now. But because of the short time that was given to all the entities that have to comply with HIPAA to comply with this new requirement, because we didn't know what the rule meant, we didn't have all the details as to what, when the notice of breach was triggered and whatnot. According to the interim rule, sanctions won't be imposed by the Department of Health and Human Services if there's a failure to provide any required notification is committed within 180 days from August 24, 2009. So if you fail to issue a required notice between now and February 22nd, 2010, then you won't be penalized by the Department of Health and Human Services. So that gives entities time to implement policies and procedures to comply with this new requirement. So what is this new requirement? The breach notification rule only applies if there's a breach of unsecured PHI. PHI is considered unsecured if it's rendered unusable, unreadable, or indecipherable to unauthorized individuals through the technology or methodology approved by HHS. According to HHS, those guidelines are, those methodologies or technologies are encryption and document destruction. There are some NIST guidelines that, so you just can't do any old encryption or any old document destruction. You have to comply with the NIST guidelines for encryption or document destruction. Now, if you're a covered entity or business associate and you do have NIST compliant encryption and document destruction, then your PHI is considered secured, and you're not subject to this notification requirement because their PHI is considered secured. If the information that you have is not secured by NIST compliant encryption or NIST compliant document destruction, then you're subject to this requirement. To determine whether this notification requirement is triggered, you have to ask whether there's been a breach. There are 3 elements that you have to go through to determine whether there's been a breach that triggers the notification requirement. First, you have to ask, was there an acquisition, access, use, or disclosure of PHI that constitutes an impermissible use or disclosure under HIPAA? essentially, was there a violation of the HIPAA privacy rule? If there was, then you go to the second question. If there was a violation, did the violation compromise the security or privacy of the PHI? The security or privacy of PHI will only be considered compromised if it poses a significant risk of financial, reputational, or other harm to the individual. So there's a risk assessment that covered entities and business associates have to conduct to determine if there's been a significant risk of harm relating to that violation, which would constitute a breach, and in turn trigger the notification requirement. Some of the factors that should be considered are who used the information or to whom was the information disclosed. There's probably not a significant risk of harm if the disclosure was made to another entity, that's also subject to HIPAA. They're already subject to the same privacy rules or other similar privacy rules. Were immediate steps taken to mitigate any harm relating to the impermissible use or disclosure that is less than a significant risk? Whether the disclosed PHI is returned before being accessed. For example, if there was a laptop that was lost and then was immediately recovered, and a forensic specialist was able to determine that none of the information on the laptop was accessed, there's probably not a significant risk of harm. Another factor to consider is whether the type and amount of PHI poses a significant risk of financial, reputational, or other harm. Like a harm could be the risk of identity theft. If the PHI includes social security numbers, then there's probably a risk of significant harm or mother's maiden name. Those are the types of information that people, once they get a hold of and if they want to use it for nefarious purposes, there's a risk of identity theft there. So that's probably a risk of significant harm, which would trigger the notice of breach requirement. Also, if the information discloses whether someone received treatment, whether you got the name of a person and that the fact that the person received treatment at a substance abuse treatment rehab facility, that probably poses a significant risk of harm to that individual because it's a reputational harm. So there would probably be notification requirement triggered there. There are a few exceptions to the breach notification requirement. You've gone through your risk analysis, and then you determine, does an exception apply? One of the exceptions is whether the breach was an unintentional acquisition, access, or use of PHI by a workforce member or other individual who's acting under the authority of a covered entity or business associate if it's done in good faith and within the scope of authority. For example, if you have a billing employee who receives and opens an email that contains PHI about a patient which a nurse mistakenly sent to the billing employee, if the billing employee tells the nurse and then deletes the email, there's no breach here. There's an exception here because it's an unintentional acquisition or access of use of PHI. If the disclosure was inadvertently made to someone who's actually authorized to access PHI at the covered entity or business associate, that's also not considered a breach that would be subject to the notification requirement. Another exception is if the disclosed PHI could not be reasonably retained by the person to whom the disclosure was made. For example, if explanations of benefits were sent to the wrong address and are returned by the post office unopened as undeliverable, then the notification of breach requirement is not triggered. Because the people at the wrong addresses who actually got the EOBs, the people who were at those addresses, I should say, they never got a chance to open the PHI, to access the PHI. So you find out that there's a violation of the privacy rule, and you determine that there's been a significant risk of harm to the individuals who are the subject of the PHI, and you determine that no exception applies. Then after you've made that determination, you know now that a breach notification requirement has been triggered. So who must the notice be provided to? You have to provide the notice to affected individuals, the media. This is a big thing. If 500 or more residents of a state or jurisdiction are affected, you also have to notify the Secretary of Health and Human Services and the covered entity if the breach is discovered by the business associate. So if the business associate is the one who commits the breach, they don't have any obligation to notify the affected individuals. The notification requirement belongs to the plan or the healthcare provider or the healthcare clearinghouse. The business associate is only required to notify the covered entity, the plan, that there's been a breach, and to provide the covered entity with the information that the covered entity needs to implement the notice. In the notice to affected individuals, a plan or other covered entity or healthcare provider has to inform the affected individuals about the breach without reasonable delay, but in no event later than 60 days after the breach is discovered or should have been discovered by using reasonable diligence. So it's a pretty prompt notice, pretty quick notice deadline. You have to write the notice in plain language, and essentially the notice has to be sent via first-class mail. You can't send it electronically, really, because realistically, the electronic notice provision is only permissible if the person has already agreed to receive notices electronically and they haven't withdrawn their agreement to receive such information electronically. If you don't have that affirmative agreement to get electronic notices, then you have to send the notices via first-class mail. When you send the notices have to include a description of what happened, including the date of the breach and the date that the breach was discovered, if you know it. You also have to describe the types of unsecured PHI that were involved in the breach. Were they names, social security numbers, whatnot? Essentially, you want to be able to give the information that an individual needs to know so that they can take the steps to protect themselves, and you actually have to tell them how they can protect themselves, like say contacting the requisite credit agencies and whatnot, especially if Social Security information was disclosed. You also have to describe what the plan or healthcare provider is doing to investigate the breach, to mitigate any harm relating to the breach, and to protect against future breaches. And you have to include information regarding contact information for any questions, including a toll-free number, email address, and whatever website you have or postal address. If the affected individuals are dead, that doesn't mean you don't have a notice obligation. There is a notice obligation. You have to notify the deceased next of kin or personal representative. Personal representative usually is like the executor of the estate or the administrator of the estate if it's if the person died without a will. If the information, the contact information that you have for affected individuals is out of date or unavailable for 10 or more individuals, then you have to provide substituted notice for a period of 90 days. So that means you put a notice on your website if you have one, or you put a conspicuous notice in a major print or broadcast media in whatever geographic area where you believe the affected individuals might reside. So if you have this, if you have out-of-date information for people, it's your burden. It's the health plan or healthcare provider's burden to to show that you made an effort to locate these people and to provide the substituted notice. Here's probably the biggest part of the new notification requirements, the notice to media. If the breach involves 500 or more residents of a state or jurisdiction, a covered entity has to notify a major media outlet of the breach within 60 days of the discovery of the breach. This is triggered if 500 or more residents of the same state or jurisdiction are affected. So if you have 200 residents of California, 200 residents of Colorado, and 200 residents of New York who are affected by a breach, the notice to the media requirement, it has not been triggered because you haven't met that 500 or more resident threshold. If there's been a breach, you also have to notify the Department of Health and Human Services. If the breach affects 500 or more individuals, regardless of where the people are, regardless of where those individuals reside, the covered entity, the plan or healthcare provider, has to notify the Secretary of Health and Human Services immediately, but no later than 60 days after the discovery of the breach. There's actually a website with the form, and I've provided the website address for you on the slides. That is the website address that you use to provide the notice to the Health and Human Services. It's a web-based notice. If fewer than 500 people have been affected by the breach, then a plan or other covered entity or healthcare provider is only required to log that breach for that year. And then at the end of the year, the plan or healthcare provider is required to provide a copy of that annual log to the Department of Health and Human Services no later than 60 days following the end of the year to which it relates. So if you have no breaches, then there is no obligation to provide that log. As I referenced earlier, the notification of requirement belongs to the covered entity. In this case, it's the health plan and healthcare provider or healthcare clearinghouse. Even though business associates are now directly regulated by HIPAA, they don't have this notification of breach requirement. If the breach is committed by the business associate, the business associate's only requirement under the statute, under the HITECH Act, is just to notify the covered entity of the breach and to provide the information that it has for the relating to the breach, so that the covered entity can actually send out the required notification. So it's who were affected by the breach, what happened, the date that it happened, the date that the breach was discovered, and any other information that the plan needs to provide the notification. So with this, because business associates don't have this notification requirement, if you're a plan or a healthcare provider, you may want to build in protections in your agreement with the business associate, requiring them to perhaps indemnify you for any losses or expenses that you incur relating to any breach that they've committed and any required notification that you have to provide in connection with that breach. And you also want to make sure that the business associate, under the terms of your contract, gives you the notice of it right away. So what we've been usually doing is requiring the business associate to tell the plan of any breach within like 2 or 3 days of the discovery of the breach, because there is a 60-day notification window that the plan has to comply with when they issue the notice. So that's the end of my slides. I believe there's some questions.
Oh, thank you very much, Tiffany. We would like to go ahead and first address the questions for the CME and MOC credit associated with this program, And remind attendees, this is your time now to submit your questions electronically for the time that we have remaining to be answered. The first question, yes or no, does a health plan violate GINA if it provides a reward to employees who complete a health risk assessment that includes an optional section that asks questions about family medical history?
That type of arrangement, if the HRA is a one-part HRA, meaning it only consists of one part and it's not a two-part HRA, I would say that HRA violates GINA and the regulation, and it's because the regulations provide for the regulations allow for the collection of genetic information if the HRA is divided into two parts and the reward isn't conditioned, if reward for completing the first part is not contingent on the completion of the second part of the HRA. Because this HRA is designed to be a one-part HRA with an optional section that asks information about genetic information, then that's a problem. This is a problematic HRA.
Thank you. Number 2, yes or no. Does GINA prohibit healthcare providers from requesting that an individual undergo genetic testing?
No. The GINA places no limitations on a healthcare provider's ability to provide treatment to individuals to whom they are providing care. So if a healthcare provider determines that an individual should get genetic testing or genetic services for whatever it is that the healthcare provider is providing treatment to the individual for, then GINA has no limitation on that. The healthcare provider is free to request that the person undergo those testing services.
Thank you. Number 3, yes or no, does the breach notification requirement apply if a workforce member sent a NIST complaint, encrypted email to the wrong individual?
So you have an individual who works for a covered entity, and that covered entity has encryption as a methodology or technology that they use to secure their PHI. And that encryption technology actually complies with the requirement set forth by NIST. If that's the case, then that PHI, that encrypted PHI, is actually considered secured. Because it's considered secured and not considered unsecured, it's not subject to the notification of breach requirement. So even though the email was sent to the wrong person, the notification of breach requirement hasn't been triggered. So you don't have to issue a notice to the affected individual. You just have you've just had a situation where you violated HIPAA, but it's not a breach for notification purposes. So no notice is required.
Okay. Number 4, yes or no. In conducting the risk assessment to determine if an authorized use of PHI poses a significant risk of harm, the covered entity determines that the PHI only includes names in the medical group where the individuals received care. Does this constitute a significant risk of harm that triggers the notification of breach requirement?
Arguably, no. The preamble to the regulations of the notification of breach rules state that this type of information, name and the fact that the person received medical care at XYZ medical group, that type of information poses less than, according to the preamble, this type of information poses less than a significant risk of harm to the affected individuals. However, if the name of the medical group is substance use disorder rehab facility, then there may be a problem. Or if it's oncology center, then there may be a risk of significant harm to the individuals who are the subject of the PHI, in which case there may be a notification requirement.
Okay, number 5, yes or no. If a business associate breached the PHI of several of its client health plans, $200,000 200 individuals for client A, 200 individuals for client B, and 150 for client C. Do clients A, B, and C have to notify the appropriate media outlets of the business associate's breach?
The answer here is no. The media notice requirement applies only if the PHI of 500 or more individuals of the same covered entity is breached. Here, the 500 individual thresholds for clients A, B, and C haven't been met. So clients A, B, and C only have to provide notice to the affected individuals and to the Department of Health and Human Services via the annual log that they maintain. So that would be the notification requirement here, even though technically 550 people have been impacted by the breach.
Well, thank you very much for addressing those questions, Tiffany. We are now going to address some of the questions submitted by attendees. Dr. Hamel, are you able to ask those questions?
Sandy, I see one question, so I can ask that one, and if there's more, then maybe you can help me out.
Sure.
One of the questions, Tiffany, is, are the medical practitioners who work for a company's occupational health clinics allowed to ask questions about family history during a periodic or pre-placement exam? This assumes that all the information obtained is kept in confidential medical files and not shared with HR.
It depends on. So let me back up. When were the why were the questions asked? They were in connection with pre-employment. Is that what?
Yeah. So during we in occupational medicine often do pre-placement exams before a person actually comes on board to set a baseline of their health.
Yeah.
And so during those, a normal part of a medical history is asking for family history.
I do know that that GINA places restrictions on the extent to which you can collect that type of information, like ask family medical history in connection with post-employment inquiries. So I don't believe that there is any limitation where the inquiry is pre-employment, but you know, you do have the other layers of protection, ADA. If that request complies with existing ADA requirements, then there shouldn't be any limitation.
Right.
I need to preface this by saying my specialty is not employment law or ADA, so you know, you should verify with your employment law counsel on that. But from my reading of the guidance so far, I don't really see any limitation on that.
Okay. Well, another comment and question submitted was, this has been very helpful as a summary of what GINA says cannot be done, but can you summarize what can be done regarding the use of HRAs and health management programs and the use of incentives by employers? For instance, does asking about whether a person has chronic conditions like diabetes or heart disease in an HRA constitute forbidden genetic information?
No. That type of information, when you're asking about the actual manifested diseases that people may have, an employee has already, then that wouldn't be subject to GINA.
But if you ask about whether the family has had a history of diabetes, then that is in conflict with
You're absolutely right, Pam. If you're asking about family medical history, whether they've had a parent or grandparent who has that disorder or condition, then that would be problematic under GINA.
So technically, the personal health assessments right now that are being used that ask about family history, if there's an incentive being awarded to the employee for participating, the best thing to do is remove that family history section.
Yeah, I mean, if you want to get at the other information regarding what the person actually has, what their issues are, like what their cholesterol level is, what their blood pressure is, and that information provides is valuable to the plan, then to avoid any GINA issues, then you should keep the incentive but delete the questions relating to family medical history, because you still want to know the information about that specific individual.
Correct.
Yes. So those are still permissible.
Sandy, are there any others?
I have to preface my comments actually. As I mentioned at the beginning of my presentation, there are different federal agencies that are charged with administering and enforcing GINA. You have the Department of Health and Human Services, IRS, and the Department of Labor. Those entities are charged with Title I of enforcing Title I of GINA. So the health risk assessments, what health plans and health insurance issuers can do. The other agency that's charged with enforcing Title II, and that has to do with employment discrimination on the basis of genetic information. That is enforced by the EEOC. At times, the EEOC and the other three agencies that I just mentioned aren't always on the same page. So sometimes you'll get guidance from the EEOC that seems to say, well, no, you can't ask that information at all for any purpose, even though Department of Health and Human Services, IRS, and DOL have said it's okay for purposes of health plans and health insurance issuers. EEOC at times in informal guidance has said, no, that information is not permissible. You can't collect that information. So there's a disconnect between the agencies, and it's made a lot of given a lot of employers headaches in terms of, well, then how do I comply?
Dr. Himmel, I have about 4 questions that were submitted initially, so I'm going to go ahead.
Oh, okay, because I see a couple now coming in too. So,
what about family history during a pre-placement history or physical?
That it's pre-employment offer.
Mm-hmm.
I'm not aware of any restriction on that by GINA. There's probably existing restrictions on that under ADA, that there's still an obligation to comply with other applicable laws.
So Tiffany, there's another one sort of along the same lines about the fact that does GINA restrict the questioning of family history when obtaining an initial evaluation for a work-related injury? So if someone is employed and has occupational medicine, workers' comp.
Yeah, you know what? If you need that information for the purpose of administering workers' compensation, then GINA places no restrictions on that.
So then to add on to that, can then the information be sent to the workers' comp carrier?
It can be. If it's necessary for the disclosure to be made for them to administer it, then yes. What GINA does is it's not intended to interfere with an employer's ability to comply with other laws. So if there are other laws that you have to comply with, such as workers' compensation, the Family Medical Leave Act, the ADA, let's say someone asks for additional leave as a reasonable accommodation under ADA or the state law equivalent, and the genetic information is necessary in order for the employer to have the necessary certification to administer that, then GINA places no restrictions on that.
Great. Go ahead, Sandy.
Does GINA apply to life insurance?
No.
Okay, the presentation seems to suggest that GINA policies are applicable towards group health plans and health insurance issuers. Does GINA apply to third-party companies that provide HRA and wellness services where collected information is kept confidential and blinded to employers?
So this is if you work for, say, a disease management company or a health assessment company, and you collect the information, but it's blinded to employers. Is it applicable to these kind of corporations?
You know, it is to the extent it is. Let me back up and say that the actual entities that are required to comply with this are the health plans and health insurance issuers. To the extent that the health plan or health insurance issuer contracts or their employer, the plan sponsor, contracts with another entity to conduct disease management, that disease management agency or firm is an agent of the health plan or health insurance issuer. So any forms that those entities use have to comply with GINA or other applicable law. So you cannot contract away your obligations under a law by using a third party.
I have another question that may have been addressed, but just to make sure that the attendee's question was brought up. If two separate HRAs are offered as suggested, one excluding genetic family information, one including, can an HRA service provider incentivize participants for a portion of the HRA that does not involve genetic family information?
Yes. In fact, there's an example in the regulations that specifically permits that. You can have you have a two-part HRA. HRA number one doesn't ask any questions about genetic information. Doesn't, like, for example, doesn't have any family medical history questions on it. If that's the HRA, you tell participants, employees, complete this HRA and you'll get a reward. And then there's a second part of the HRA, there's HRA number two. If that HRA number two has questions about family medical history, that's fine as long as that HRA number two has information on it that says, oh, your completion of this HRA is voluntary and will not impact your ability to get a reward or other incentive for completing HRA number one. That's fine.
Dr. Hennall, that's all the questions that were submitted early on. So you have all the questions, I think, that have been recently submitted.
Okay, so then I have one more. No, I've got a couple, I guess. If providers of health are not restricted in what they ask for as part of their medical evaluation and do disclose medical or genetic information to an employer that was not requested, does the incidental receipt exception apply?
So the information was depends on why the information was disclosed. Was it necessary, like, for claims payment? It may not necessarily have been requested by the employer, but maybe it's necessary. The healthcare provider determined it was necessary for the purpose of the reason why the person went there. Let's say for leave purposes, administering a leave request, or for services for which the participant received for a particular condition that that person is going to submit for payment under the employer's health plan. If that's the reason why the information was disclosed, then there's no problem, there's no issue, as long as the employer doesn't use that information to retaliate against that employee.
Mm-hmm. Okay.
But, if the information is needed by the employer to process that individual's claims or to process that individual's request for leave or other reasonable accommodation, then that should be fine, because it's the employer needs that information.
Okay.
And once that information is in the employer's hands, the employer is obligated to comply with, the confidentiality laws, making sure that it maintains the confidentiality of that information and make sure that it doesn't use that information for any retaliatory purposes.
Right. Okay. So that's the key, no retaliatory purposes. Mm-hmm. So another question, again, on examination. So for annual physicals or post-employment physicals, mm-hmm. The acquisition of family history, how does GINA apply to those? Generally speaking, employers. So those are in connection with examinations by healthcare providers of the employees. Yeah. So, for instance, many companies contract with physicians who may may do annual physical exams on their patients. So how does GINA apply for those? Because a family history would be part of an annual physical. And conversely, because of the nature of some of the work that people do in these corporations, they do post-employment physicals to check on their state of health as they leave the company.
Yeah.
Can you take a family history?
I mean, that's a really difficult question to ask because in some instances, that information is necessary because a lot of entities, a lot of companies where employees work are publicly traded, and sometimes that information, if it's not disclosed that you have someone who has this genetic disorder that could manifest itself, that could, someone could file a lawsuit for not disclosing that to shareholders. But at the same time, genetic information is now a category of information that is subject to special protection now that wasn't afforded to it before. My inclination, like I said before, I'm not an employment law employment law attorney. My inclination now is to say that information can't be used.
Cannot be used.
I said if it's necessary for the healthcare provider to provide the treatment, but disclosing that information to the employer, I don't think can be done.
Right. So if they do a post-employment annual exam, but the information never goes to the employer or other healthcare entity, but certainly the physician, in part of their due diligence in doing an adequate exam, collects the family history, but it stays in the medical record.
Yeah, that's
a problem.
Fine.
That's not a problem.
No, I mean that's if, that's fine.
Okay. Many of our physicians, are sort of between a rock and a hard place between doing what's right for the patient and doing adequate exams and then, trying to comply with these regulations that get levied upon people arbitrarily. And so,
yeah, I mean, because before GINA, that information could be used and disclosed.
Yeah.
Now with GINA, it can't.
Right. But it's still a critical part of doing a complete exam.
Correct.
So, Sandy, any other questions then?
Yeah, let me just make sure that all these were addressed. So if they were, just let me know. Can family history be asked in a post-employment annual exam if the info never gets to the employer or any other healthcare entity?
Yeah, we just addressed that.
Okay. Then there was one that was submitted regarding does GINA restrict the questioning of family history when obtaining a history for an initial evaluation for a work-related injury?
Yeah,
they addressed that.
Yeah.
Can you collect family history information while conducting an exam for a workers' compensation industry illness? You got that one? I think we're up to date, but we do have one more that just came in. I do physicals for police, fire department, and hazmat personnel, which includes discussion of cardiac risk factors, including family history. This may give rise to further evaluation by a cardiologist, which is paid by the employer.
So can they collect that family history? Because it's
in
some respects critical to ensuring the safety of the worker.
Yeah, I mean, because there are different, like I said, I'm not an employment law attorney, but from what I know, that in certain professions like peace officers, police officers, and firefighters, and related public safety examinations and the health of those individuals who are in those professions is critical. So I know there are carve-outs as to the types of questions and examinations that you can ask those people under the ADA. I imagine that there are similar carve-outs with respect to the types of questions that you can ask of these individuals. I'm not sure that that's been fleshed out yet by the EEOC. That should be in further guidance, but it would seem strange that they would restrict your ability to get that information when you can get that information from these people post-employment because their health, you can ask those types of questions for these types of employees.
That was all the questions that have been submitted, Dr. Himmel.
Okay. Well, I think this was a very robust discussion on a very intricate subject. So, Tiffany, thank you very much for taking the time to bring us all up to speed on this area. And Sandy, we'll be posting this, right, for all participants?
All the attendees will get an email in the next 24 hours with access to the recording to view the recording online for the next 2 weeks.
All right, thank you, guys. Thanks for your time.
Thanks to everyone.
Okay.
Thank you for everyone.
And for any ACOM member, do not forget to vote in the ACOM election, which is going on again till the end of this week. And then also, don't forget AOHC in May 2010 in Orlando, Florida. Have to get those advertisements in. So thanks very much.
Thank you.
I'd like to thank everyone for their attendance and for their valuable presentation by our presenter today. This concludes today's program. You may disconnect.